Hi friends, in the recent news there was an observation on Article 32 by a Supreme Court bench headed by the Chief Justice S.A. Bobde. The observation was, it is trying to discourage the individuals from filing any petitions under Article 32. It was made during the hearing of a petition of the arrested journalist. They were arrested on their way to Hathras in Uttar Pradesh to report a gang rape and murder case. In this video, we'll be looking at the Article 32 and its special features. So let's begin. So first let's look at the constitutional terms of this article. Article 32 has 4 clauses. According to the first clause, it is giving a guarantee to the people that the Supreme Court has the right to enforce the fundamental rights. The second clause deals with the different types of writs which can be issued by the Supreme Court. They are habeas corpus, mandamus, quo warranto, certiorari and prohibition. The next clause gives some special powers to the Parliament that the above mentioned rights can be given to any court in the territory of India by a law. And the last clause deals with the suspension of this article under emergency situations. Now let's look at the features of Article 32. The first and the important feature is that the provisions given in the Article 32 is a fundamental right. We know the articles from 12 to 35 are included in the third part of Constitution, which is considered to be the fundamental rights. The speciality of the fundamental rights is that it can be enforced by a court of law. The Article 32 is popularly known as right to constitutional remedies. It is a fundamental right as well as it is an effective machinery to enforce the fundamental rights. As the Article 32 guarantees to enforce the fundamental rights, it is actually protecting all these rights. So according to Dr. B.R. Ambedkar, without this article, the fundamental rights will be meaningless. So he considered this article as the heart and soul of the Indian Constitution. And other members of the drafting committee mentioned that this right is fundamental to all other fundamental rights. So we have to note one more thing, that this article is protecting only the fundamental rights, not any other constitutional or legal rights. As the Article 32 empowers Supreme Court to enforce the fundamental rights, the Supreme Court is considered to be the protector as well as the guarantor of the fundamental rights. Also, the Supreme Court has ruled that the Article 32 is a basic feature of the Indian Constitution. Hence, this right cannot be taken away or be amended. In any civil or criminal matters, the first remedy is in the trial courts, then followed by the High Court and then the Supreme Court. But in the case of an infringement of the fundamental right, any Indian citizen can move directly to the Supreme Court. And this right is protected under the Article 32. And the last point is that this right cannot be suspended except emergency conditions. Now let's move on to writs. According to the clause 2 of the Article 32, there are 5 types of writs. The first one is a habeas corpus. It is a Latin word which means to produce the body. It helps to protect the personal liberty in case of illegal detention and wrongful arrest. The court can issue a habeas corpus writ against a public authority as well as a private individual. If such a writ is issued, the person has to be produced in the court and the court can verify whether his detention is legal or not. If it is found illegal, the court can take action against them. The second type of writ is the mandamus. It literally means we command. By issuing this writ, the court is directing a public official or government or even court to perform their official duty. This type of writ is issued only against public officials and it is not meant for any private individual. The next type of writ is the quo warranto. In literal sense, it means by what authority? This type of a writ is issued to show by what authority or by what warrant a person is holding the public office. Using this writ, the court can verify the eligibility of a person. Next is prohibition. This writ is issued to direct a judicial or quasi-judicial authority to stop its proceedings, which it has no jurisdiction for. So, if a higher court feels that the lower court is exceeding its limits, they can issue this kind of writ to stop the proceedings. The last one is a certiorari. It is for the re-examination of any orders provided by any judicial or quasi-judicial or any administrative authority. This writ is issued by any higher court to a lower court to transfer any cases pending with them or to squash any orders delivered by them. So, unlike the prohibition, which is only a preventive one, the certiorari is preventive as well as curative. The discussion on Article 32 will be incomplete without Article 226. We know the Article 32 is a law which gives some special rights and features to the Supreme Court. With the help of Article 226, High Courts are also given similar rights. First, let's see the similarities between Article 32 and 226. The Article 226 is also for the enforcement of fundamental rights, which is through the High Courts. Also, the High Courts also have the power to issue writs. So, if a citizen is having a violation of fundamental right, he can directly move to Supreme Court or to the High Court. It has to be mentioned that Article 226 has wider scope than the Article 32 because by definition, the High Courts can issue writs for the enforcement of fundamental rights and for any other purpose. With that sentence, for any other purpose means that the High Courts can issue writs not only for any fundamental right violation but also for any other purposes. So it's having a wider scope than the Article 32. Now let's look at the differences between Article 32 and Article 226. First of all, the Article 32 gives some special rights to the Supreme Court, whereas the Article 226 gives right to the High Courts. Second point is that the Article 32 itself is a fundamental right, but the Article 226 is not a fundamental right. It is just a constitutional right or a legal right. The writs issued by the Supreme Court is only for the enforcement of fundamental rights. It doesn't have any other purpose. Whereas under Article 226, any High Court can issue the same writs but not only for the fundamental right violation but also for any other purpose. Now the jurisdiction. We know the Supreme Court is having jurisdiction in the entire territory of India. So the Article 32 is also applicable everywhere in the territory of India. Article 226 will be applicable only for local jurisdiction of the particular High Court. But we have to note that the High Courts can issue writs anywhere in the territory of India if the course of action arises within its territorial jurisdiction. We know Article 32 is a fundamental right. So the Supreme Court cannot refuse to exercise its writ jurisdiction, which means if there is a petition filed under Article 32, it is mandatory for Supreme Court to take action on it. But in the case of Article 226, which is not a fundamental right, it is discretionary for the High Court to accept or reject it. The last point is that the rights under Article 32 will get suspended during the emergency period, but it is not applicable for Article 226. The rights will not get suspended during the emergency period. These are the differences between Article 32 and Article 226. From the recent observation by the Supreme Court that it is discouraging individuals from filing petitions under the Article 32, which means the fundamental right is getting violated, which is against the ideas of our Indian Constitution. In this video, we have seen the Article 32 its special features and the comparison with Article 226. Thank you.